Welcome, everyone, to the NAIOP Solutions Series. My name is Sheila Vertino, and I'll be the host for today's program. As you know, the main goal of the Solutions Series program is to provide NAIOP members in a very short period of time with some practical strategies, some positive insights, things that will help you succeed in today's rather tough business environment. As always, we encourage you to drive the content. Let us know who you'd like to hear from in future programs, what the topics are. You can send us an email, or you can just tack it on to the evaluation that you'll receive at the end of today's program. I'd like to begin the program by thanking our sponsor, and that is the Harvard Business School Real Estate Executive Education Programs. Their education programs are designed to help seasoned and emerging leaders protect their assets and manage complex projects. In addition, participants will gain the skills they need to navigate global markets and capitalize on new opportunities. If you're interested in the Harvard programs, please visit the website. That's at www.exed.hbs.edu. Tim, if you could help me and advance to the next slide. As I mentioned, the Solution Series is great for these short bursts of information. Of course, some topics need a more intensive and thorough exploration. And for that, NAIOP has 90-minute webinars. The next full webinar will take place on Thursday, June 10th. And during that webinar, we have Art Lomanik and Neil Montgomery, and they will discuss the Downtown Garland Transit-Oriented Development Partnership that they have with the City of Garland and High Street Residential's role as master developer. The cost for the webinar is $65 for NAIOP members and $95 for non-members. If you'd like to register for the 90-minute webinar, you can go online to naiop.org/webinars. Okay, and now we're ready to get on with our Solution Series program today. With us is Timothy Miedona, and he is partner with Lowndes, Drosdick, Doster, Kantor, and Remedies, PA. Tim's areas of expertise include commercial leasing, real estate transactions, development and finance, and corporate and securities. He has represented commercial landlords and tenants in the development and leasing of office, medical, and retail properties, as well as commercial lease workouts. Welcome, Tim, and thanks for being with us today to shed some light on how we can expedite the commercial leasing process, save time, and perhaps save some money. Thanks, Tim.
Thank you, and I'd like to first thank NAIOP and our worldwide web audience for having me here today, and I look forward to talking to you. As discussed, the topic today is going to be streamlining the commercial leasing process. You know, throughout the 2000s, I had the benefit of doing several different types of leases in various projects, including retail, office, hospital, and then back when people in Florida were building houses in some of the lifestyle centers. And so I've seen a lot of different types of activities and different negotiation points, and I've represented primarily landowners and landlords, but I have done some work for national tenants in various spaces, including kind of airport spaces, office space, some spaces in the Las Vegas Strip, the Magnificent Mile, Chicago. So I've seen kind of a wide range of leasing and what's important to various folks. So, you know, without further ado, I'll go ahead and get started with the project here. Let's see. The first place where I would start as a landlord or owner of a piece of land or existing improvement is really understanding what your project is and what you hope to accomplish. The very first place where you'd want to start is understanding what your property is zoned for. So you'll need to, hopefully by at this point, you understand what you have and what you own and what is permitted by local laws. And then the next thing you would like to do is just go ahead and do a survey and obtain the market information regarding your project. This will give you an idea of what the rental rates are for your area and for your space. Ways to obtain that information would be through the broker community would be my first place to look. You can talk to various business owners in the area and go through the business community. The information is available, and you should not have a difficult time obtaining that. The next point here is if you have a mortgage on your property, presumably there's going to be various restrictions in your loan documents. You'll need to refresh yourself on those documents and understand what permitted uses are available in your building or your property and what sort of renovations are allowed. The next thing you'll want to get from your lender is their Form SNDA, Subordination, Non-Disturbance, and the Torment Agreement. This is something that you'll want to agree in your LOI that will be attached to your form lease. The SNDA is actually a point that gets negotiated quite heavily, so having that document up front and having your lender's form ahead of time will save plenty of time. The next point you'll want to determine here is find out if your lender is going to require that any occupant or tenant of your project has to have a certain net worth or tenant credit requirement. And then the last thing you'll want to do with your lender is have your form lease approved ahead of time. Typically, and we're going to get into this a little bit later when we talk about the LOI, but if you've got an office building or a shopping center, you're going to want to have an attorney draft a form lease for your project. You'll want to have that then sent to your lender for their approval and comments, and that would be a good starting point. Once you've kind of gotten through your lender requirements, if you have debt on the property, the next thing I'd want to do is take a look at the title and the title restrictions which impact your property. Sometimes there will be deed restrictions on your property which will require use, and that will point to you as to whether or not you're able to do the various leases and the projects that you intend to do. And if you are doing some releasing of an existing building, there's presumably existing leases in place. You're going to want to take a look at those too to see if a exclusive or other use restrictions were put in those leases which would have an impact on your project. The next point we're going to get to is the letter of intent process. Typically, these used to be 1 or 2 page term sheets which basically spelled out the rent, the term, and some various minor other issues. The LOI process itself has gotten way more intense, and it's actually a good way for folks to limit the attorney involvement in your lease negotiation. So my recommendation for landlords and tenants is to negotiate as much as possible in your letter of intent. One of the big reasons, obviously, is that the folks in the business community, I think there's built-in efficiencies for those folks to resolve their business issues, and, as opposed to having the attorneys involved try to negotiate rent and some other terms. And we're going to go through in this LOI presentation kind of the big issues that get negotiated heavily over time. The first issue for a commercial landlord is to determine who their tenant is going to be and what the credit's going to be on the lease. As kind of discussed earlier, your lender might have requirements as to who that can be. So the first thing you want to do is determine who your tenant's going to be, do some background on their financials, and make sure they meet any lender requirements. If there are no lender requirements, just as a good practice point as a landlord, you're going to want to know that you can get paid. So you're going to want as much credit as you can, so that might require a personal guarantee as opposed to just doing a lease with a formed shell company, LLC. The next issue, which is probably the biggest issue for both the tenant and the landlord, is determining your rent. As we discussed at the beginning, as you try to understand what your project is, you're going to obtain your kind of market information. So you want to make sure you're starting at a reasonable rental rate for what your project entails. And in this kind of economy, we've got various inducement options which a lot of landowners and tenants are requiring landowners are having to give, and that includes free rent periods. The tenant would have maybe free rent for, I've seen anything from 8 months to a year in these times. And then there's also various opening co-tenancy requirements. And by that, I mean, if you have a shopping center or an office building where foot traffic and various other things are going to be important to the tenant, they're going to want to know that they're not going into an empty space where there's not going to be, various other businesses around them. So tenants will require that there are other businesses open, and a lot of times they will have an opening co-tenancy such that the tenant will not be required to open or pay rent until a certain percentage of the building or shopping center or project is occupied. The next point here is percentage rent. This is something a little more common in your retail and restaurant business, but some landlords, in order to kind of participate in a tenant's upside, will also do a percentage rent, which is basically you would get the landlord would be entitled to a percentage of gross sales over a breakpoint amount. If you go into the percentage rent world, the important things here are identifying what reporting requirements for the tenant that they have to comply with, and also probably attach various forms for reporting such information. And this can be as easy as quarterly audited financial statements or things of that nature that would allow the landlord to readily identify the sales from the property. And then the last, and this is really a major issue and a major negotiating point, but if we can identify this in the LOI and really spell out what it is, it's going to cut down significantly the amount of time and a lot of the negotiation, and that is identifying the CAM, which is the common area maintenance and operating expenses for the project, and what those exclusions are. What you'll get into here is basically, as a landlord, you want to have this as broadly defined as possible. You want the ability to pass through all of your out-of-pocket expenses for owning the property. So that's going to include all of your insurance, all of your taxes, all of your maintenance, capital improvements. If you've got to put a new roof on the building, you're going to want to have the ability to pass that through as part of the package that goes to the tenants. And the tenants obviously are going to want to narrowly define this. They might not want to pay for any capital improvements. They won't want to pay for a roof. They might, they're going to want to fight on any management fees, and they might want to have annual caps on what these expenses are. So this is really kind of a business issue, but it's one that really needs to be identified in the letter of intent. Otherwise, your attorneys are going to take a lot of time and effort trying to pare these items down. Next item I want to talk about are the rent commencement dates, and this really kind of ties into the term as well. If your building needs a lot of retrofitting, or you're building from the ground up, you need to really understand your timelines for construction and for what would be a realistic build-out period for a tenant. If you're the landlord, you're also going to want to identify an outside date. What I typically see is a landlord state that it's going to be X amount of days after the tenant receives its permits. It'll be the earlier when the tenant opens for business, or just a certain time frame after lease execution. This is really important for a landlord because it ties the tenant into where they have to start making where your rental stream actually starts. And as a practice pointer, I would tie your term to the anniversary of the rent commencement date as opposed to the anniversary of the lease signing date. In the event there's any delays, you would want to know that you're getting, for example, 5 full years worth of rent as opposed to 4.5, if there was a period where they're not paying rent. And additionally, what I would like to do here, if I was a landlord, I'd also want the tenant to start paying the additional rent, which is the CAM, insurance, taxes, etc., starting on the lease execution date as opposed to the rent commencement date. But that's really a matter of negotiation, and right now it's kind of about a 50-50 split on how that plays out. The next issue is permitted uses. Again, what you'll want to do is confirm that the use that your proposed tenant is going to have is in compliance with your loan documents, your title exceptions, any other lease restrictions that you've put in with other occupants existing at the time of the lease negotiation. And I would probably just attach these as an exhibit to the LOI, or you can just generally put a provision in your LOI that says that the tenant will comply with these items and then attach them to the lease. Again, if you're the landlord, you're going to want to narrowly define what the permitted uses are for such tenants, just so that you don't have a tenant, if you put a provision in there that says the tenant can use it for any retail purpose, that might allow a tenant to infringe upon another occupant's exclusive use if one was granted. If you're the tenant, you're going to want the ability to kind of use it for any lawful purpose, and this will allow you much more flexibility to assign and sublease as a tenant to any sort of user, as opposed to having just a pool of users that would be able to do that. So this is a big point of contention. Again, if I'm representing the landlord, you really want to make this use provision pretty tight, and you want to make sure that a tenant does not do anything which would violate any existing restrictions, or any restrictions actually that you'd want to put in place in the future. So, for example, I did a shopping center in Central Florida where we had a big anchor kind of be the first major tenant. Then we filled in various kind of shop space tenants. And if we didn't have a tight use provision clause there, we might have allowed them to sell items which would have competed with, some of our big box users that were moving, that we're going to move in later. So that's why you really want to make this provision tight and narrow, and really just have the specified use. And the use provision really also ties into the assignment and subletting, as I kind of spoke about before. A tenant will look to assign, they want to freely assign and sublease their space, and they won't have the use issue if you don't have your use issue tight. So the first thing you want to do here is check with your lender, again, in your loan documents, to determine, if there are restrictions on tenants assigning and subletting. The second issue here is as a landlord, you're going to want to have consent rights to any assignment or subletting. And this is another issue where tenants are going to push back, because if for whatever reason this location doesn't work for them, they want the ability to assign or sublease to another user to kind of offset some of their costs. Typically, where we end up on a lot of deals is we state that the landlord will have approval rights. The tenant will then try to carve out various entities that they might have the ability to sublease or assign to without the landlord consent, and that's typically to any franchisee, to any merged company which results from the tenant merging with another entity, and those kind of entities, and that's typically okay with the landlord, but you want to make sure that you don't then allow the tenant off the hook for such assignment or sublease. And that really goes into the next issue, is what happens upon a permitted assignment or sublease. And tenants are going to fight to have some sort of release from the lease obligations, and the landlord, of course, wants to keep the original tenant on the hook. Typically, where I end up if this becomes a big negotiation point is I state that the tenant can be released if the new subtenant or assignee has a net worth requirement greater than or equal to the tenant at the time of the lease execution or at the time of the assignment. And then last but not least, the subtenant recognition is a major issue, especially in this economy with bankruptcy laws kind of impacting your leases. As a landlord, you want to make sure that you state there that there's no obligation on the landlord to recognize a subtenant, and your SNDA agreement that your lender provides should also have a similar provision. And tenants are going to fight this, but again, this is one in this economy where the landlord has the leverage, and they can basically dictate the subtenant recognition requirements on these. The next issue, which gets a lot of negotiation in the lease, is the default and remedies provision. A lot of this is legalese, so this is where the attorneys will really fight for the exposure to their various clients. The first kind of issue that you'll run into is the rent acceleration. If there's a default by the tenant under the lease, landlords are going to want the ability to accelerate the rent. This is not permitted in every jurisdiction, so you'll have to check your local law to determine whether this is even available there. But This is a big issue for landlords and tenants. It's the hammer that the landlord has to force tenant compliance, and the tenants obviously are going to want to limit their exposure. So in terms of a practice point, what you'll see as negotiation tips on this, or you'll end up with some sort of amortized and over the remaining term on the rent acceleration discounted to the market present value. And then you'll also have other compromises that I've made on this provision is to state that the landlord can accelerate up to 1 year's worth of rent. So essentially the landlord, if they were to agree to that kind of provision, would have about a year to find a new tenant while still getting their income stream for that year. Other issues in the default remedy provisions are obviously cure periods, the time periods for that, whether written notice is required by the landlord to the tenant, and then late fees that the landlord can charge. You know, again, another big issue, a lot of times I see it as 5% plus, you know, some interest tied to the prime rate on any unpaid, you know, amounts due to the landlord. And then lastly but not least, for the landlord, the big part of your investment is your rental stream. And so you really want to protect, you need to protect that, and your lender is going to require to protect that as well. So you want to have some strict prohibitions against offset rights of the tenant and any termination right of the tenant. The places where tenants are able to get this are going to be kind of your, in some instances, are your casualty and condemnation. If there's delays, or if there's, you know, something like that, or if there's maintenance requirements that the landlord is responsible for in kind of a big setting, and the landlord defaults on that obligation, and it causes a material impact, adverse impact on the tenant. Sometimes tenants will then be able to get offset rights, and if it's an ongoing thing that continues, they'll get termination rights as well. If you are in a situation where you have granted a tenant an exclusive in your project, this is kind of another big issue where tenants will try to swing a big hammer and try to get termination, offset rights, or pay some sort of alternative rent if the landlord defaults. Typically, when I represent a landlord, the way I combat this is to state that if the landlord knowingly does a violation, then the tenant would get some remedies. However, if it's a rogue tenant, you know, operating in violation of its lease, and the landlord is seeking to cure it, we wouldn't allow the tenant any remedies in those situations. For example, I've got a project, the hospital project, which has a national fast food restaurant. And one of our tenants who did not, at the time we signed the lease, and we had a tight use clause, the tenant was supposed to be selling clothes, and they decided to switch concepts and sell sandwiches, which violated our existing lease with our national fast food restaurant. So we had a problem, and so fortunately our lease with the restaurant stated that as long as, you know, we are diligently pursuing to cure, they wouldn't have the ability to terminate or offset any rental stream. So because of that protection that was in there, we were able to keep our rental stream consistent, allow our national restaurant to remain remain there and not have the ability to terminate their lease while we dealt with the rogue tenant. The other place where you'll have offset and termination rights for tenants are if you have granted any sort of ongoing co-tenancy provisions, which means, again, excuse me, I'm getting over a cold myself, which would be a situation where a tenant says as long as X percentage of the project is occupied, if it falls below that threshold, they would have remedies, which could include termination or offset. Where you'll kind of end up with that situation is you'll want a cure period as a landlord before those remedies kick in, and if you allow them some sort of discounted rent, you would want to cut that off after a certain amount and make them resume paying full rent, irrespective of whether the co-tenancy is then satisfied or not. The next issue is tenant leasehold financing. Tenants a lot of times are going to need the ability to finance their improvements. If they're a restaurant, they need money to put in their ovens, stock their shelves, this, that, and the other. first thing you want to do is check your loan documents to make sure that the tenant can do it, and then find out the terms for which they can. The other thing I would do ahead of time is prepare a form landlord subordination agreement, which I would attach to the LOI or the lease, and this would kind of expedite that process. And again, if you're the landlord, you want to resist waiving outright any landlord liens, but agree to reasonably subordinate pursuant to the terms of the subordination agreement. The next point I want to talk about is, and this is really probably the most important point if you really want to streamline your commercial lease process, is agreeing upon the lease form in your letter of intent. So if you're the landlord, you want to use that form lease we talked about at the beginning that your lender has approved, and make the tenant start with that as a starting place. And if you are a tenant, typically you're going to need to be a national tenant or have a lot of leverage. You're going to want to specify that you can attach your form addendum. Tenants will have addendums to their leases, which basically state that it has their kind of hot button issues, which might be assignment, might be use, what have you, but they're going to want to attach that to your form lease. But by having these kind of documents prepackaged, it's going to really kind of expedite the process. And one other thing I would talk about here is, if you really want to get your leases signed quickly, in your LOI I would specify an outside date for lease execution. A lot of times this isn't going to be binding, and it's not always going to be effective, but it doesn't hurt to have so that you can keep the parties moving forward and keep pressure on each side to get this thing done. Okay, now you've got this LOI, which obviously has a lot of components that we talked about today. And a lot of times you might be thinking, well, geez, we just kind of negotiated an entire lease in the LOI process. What you've done is done it a little bit condensed, and you've kind of taken a lot of the attorney involvement out. So any attorneys on the string or in our audience might be shaking their head at me right now. But I think overall you'll end up with a better result as a result of a comprehensive LOI. So now you're ready to get to the lease. If you haven't hired an attorney, you probably will at this point. And now what you want to do is understand your fee arrangement with your attorney. Fortunately for tenants and landlords, right now it's a pretty free place in terms of negotiating legal fees from law firms. There's all kinds of alternative fee arrangements that attorneys are offering in order to attract business. And you can go from flat fees to pay based on various stages to your traditional billable hour rate. So, and then once you've got the lease generated and the sides are going back and forth, presumably you'll always be able to point to your letter of intent, and hopefully the letter of intent is comprehensive and will resolve a lot of the issues. But to the extent they don't, and you can never draft ahead of time for everything, the last point I have really is just to be reasonable. I know that sounds very simple, but that's really where you need to be. I've dealt with various national development companies, national retailers, national restaurants, and the days of, well, we're X, Y, and Z, and we just don't do that. That's starting to dwindle down a little bit. So, I think there's a premium for folks that are reasonable. So, I think that'll also expedite your commercial lease negotiation.
Wow, Tim, that was a really terrific presentation. Lots of good advice there. Lots of things that will save landlords money and save time. So I want to thank you for that very reasonable presentation with lots of good ideas about the managing the commercial lease process. For those who might want to hear this presentation again, we will make it available by close of business today. And actually, all of our past presentations are available on the NAIOP corporate website. If you go to www.naiop.org and just click on the large button on the front page that says Solution Series. Our next Solution Series program is set, and it's going to be on June 16th. I'm pleased to tell you that we have Susan Smith, who's a director with PricewaterhouseCoopers. She's going to discuss the findings of the second quarter 2010 Corpass Real Estate Investor Survey. This has been going on for 23 years, so we're very pleased to have her and this type of very long-term, intense look at her topic, which is inside the minds of institutional investors. So we encourage you to watch your email from NAIOP Corporate for a message with more information about how to sign up. Again, if you have any topics that you'd like us to cover, just put them in your comments on your session evaluation survey that we'll be sending you right after this program. Thanks again to Tim Miedona, and thank you all for attending our session today. Goodbye to all.